Good morning. In this presentation, we will see the first part of Module 4, Constitution of India. The State Executive, the Governor, Article 152 to 162. Executive power is divided between the Union Government and the State Government. Union Government deals with military, external affairs, and the State Government deals with internal security and other state issues. The head of the state is a governor who is the constitutional head of the state as the president is for the whole India. There shall be a governor for each state and the governor is appointed by the president of India. Qualifications. A person to be eligible for appointment as governor should be a citizen of India and has completed age of 35 years. The governor shall not be a member of the legislature or parliament. He shall not hold any office of profit and he shall be entitled to salary and allowances. The governor shall not be a resident of the same state. It's a tradition but not mentioned in Indian Constitution. Term of office. Normally, he holds office for 5 years but can be removed at any time by the president because governor is a nominee of union government. Or he may be asked to continue beyond 5 years until his successor enters upon his office. At the same time, the governor can resign any time by writing to the president. Now, what are the powers enjoyed by the governor? Under Article 154(1), all executive powers has been vested on the governor and he can make use of this power directly or through his subordinate officers. He is responsible for running the administration of the state. He appoints chief minister and with his advice appoints other ministers, makes rules and regulation about the distribution of portfolios among ministers. Under Article 167, Governor can ask for any information from the CM regarding the state administration. He appoints the Advocate General and members of the State Public Service Commission. Next, we will see the legislative power of the Governor. He has the power to prorogue the state legislature and dissolve the state legislative assembly. Prorogue means discontinue. Second, the first session of the state legislature after general election and the first session of every year begins with the inaugural address delivered by the governor. Third, he can send message to the state legislature for consideration. Fourth, under Article 213, if legislature is not in session, the governor can issue ordinances. And this is the most important legislative power enjoyed by governor of any state. Ordinance means law. Now, if there is any circumstance in the state which needs immediate action of the governor during the break of legislature, then this article, that is Article 213, empowers the governor to promulgate the ordinance during the break of the legislature. Fifth one, Governor nominates about 1/6 member of the Upper House Legislative Council from among persons having special knowledge in field of science, literature, art, etc. Financial powers. Money bill cannot be introduced in the state legislature without his prior approval. The contingency fund. Contingency fund means emergency fund of the state is at his disposal and he can make advances out of it to meet unforeseen expenditure. Judicial power. He decides matters relating to appointment, posting and promotion of district judges and other judicial officers. He is consulted by the President at the time of appointments of judges of the High Court. He has the power of granting pardon, reprieve or reduce the punishment or to suspend relating to the matter to which executive authority of state extend. Next, we will see the discretionary powers of the governor. Appointment of CM. In case no party enjoys a majority confidence in the Legislative Assembly, then the decision about the appointment of CM, that is the Chief Minister, will be made by the Governor. Guardian of the Constitution. In case if he finds the constitutional machinery in the state has failed, he may send his report to the President on the basis on which presidential rule will be declared. Dissolve Legislative Assembly. Governor dissolves the Assembly on the advice of Chief Minister, but sometimes he has to take the decision on his discretion. Dismiss the Council of Ministers. If Council of Ministers want to remain in office even after losing the majority, the Governor can dismiss the Council. Next, the Council of Ministers and Chief Minister. Article 163. There shall be a council of ministers with a chief minister at the head to aid and advise the governor in the exercise of his function, except in so far as he is by or under this constitution required to exercise his function or any of them in his discretion. That means CM and ministers aid and advise the governor in exercising his function. But there are certain situations where the governor can exercise his function in his own discretion. There he needs no advice or aid from the Council of Ministers or the Chief Minister. Second, if any question arises whether any matter is or is not a matter as respects which the governor is by or under this constitution required to act in his discretion, the decision of the governor in his discretion shall be final, and the validity of anything done by the governor shall not be called in question on the ground that he ought or ought not to have acted in his discretion. Now, what this means is there may be or may not be matters which need the involvement of the governor in taking decision purely on his discretion. In such cases, if he makes any decision, it shall be the final one and shall not be questioned. As per Article 164, the Chief Minister shall be appointed by the Governor and other ministers shall be appointed by the Governor on the advice of the Chief Minister, and the ministers shall hold office during the pleasure of the Governor. Second, the Council of Ministers shall be collectively responsible to the Legislative Assembly of the state. Third, before a minister enters upon his office, the Governor shall administer to him the oath of office. Fourth, if a minister is not a member of the Legislative Assembly for a consecutive 6 months, then he will be removed from the post of a minister. Article 167. It shall be the duty of the Chief Minister of each state to communicate to the Governor of the state all decisions of the Council of the Ministers relating to the administration of the affairs of the state and proposals for legislation. Chief Minister of the state shall furnish information relating to the administration of the affairs of the state and proposals for legislation as the Governor may call for. Legislative proposal means it's a bill, and a bill will not become law unless it is passed in the legislature. Third, to submit for the consideration of the Council of Ministers any matter on which a decision has been taken by a minister but which has not been considered by the Council. Under this article, it is a duty of CM of a state to keep informed by the Governor all matters concerning the administrative affairs. Next, we will see the Advocate General of the state. Article 165. The Governor of each state shall appoint a person who is qualified to be appointed as judge of a high court to be Advocate General for the state. And it shall be the duty of the Advocate General to give advice to the government of the state upon legal matters and to perform such other duties of legal matters as may from time to time be referred or assigned to him by the governor, and to discharge the functions conferred on him by or under this Constitution. Third, the Advocate General shall hold office during the pleasure of the Governor. And that's the end of part 1. Thank you.